You can be seated. State waive the call.
State waive, Your Honor.
You can waive the call.
Yes, Your Honor.
You can proceed with cross-examination, Mr. Frazier.
Thank you, Your Honor. Dr. Mileusnic, how are you doing?
I think One of the questions I have for you is, I'm not sure if you covered it in direct or not, but were you able to to estimate a time frame about when Miss Christian would have been, when she would have died?
Mr. Christian, you said?
Not, excuse me. No, Miss Christian.
Oh, Miss Christian.
Yes.
Her death could have happened anytime between Sunday evening and Monday, and that's a pretty large interval because of the condition of the body, lividity, rigidity, and the state of inflammation that I found in the tissue and the time frame where the carjacking occurred. So my best estimate is really sometime Monday, late morning or early afternoon will be the best that I can come up with based on all these conditions.
Okay. And I believe that one of the items that obviously when you're examining the body, you're looking for any foreign objects, anything like that may be on the body, including foreign hairs, correct?
That's correct.
And in fact, you did collect, I believe, 3 black hairs that were collected from Ms. Christian's body. Is that correct?
Yes, I collected everything that I could notice that did not belong to her necessarily, could have been part of the scene.
And those were ultimately sent off, were they not, for examination?
Yeah, we sent everything. Everything that I collected, I sent to the via the investigating agency to the crime lab.
And with those being hairs that wouldn't have had the root attached, the only type of DNA that you could get from that would be mitochondrial DNA. Is that correct?
Yes, and it really depends. Even that would be limited depending on the condition of the hair.
And are you aware that they were tested, in fact?
I don't recall that, no.
Okay. Could I approach Dr. Mann?
Sure.
Thank you. And this is actually, I believe, cross-examination from, I believe that this is Mr. Thomas's original trial. And I know one of the questions I asked to you, and if I'll reference, it's going to be on page, well, it's asked to you originally on page 169, or yeah, on page 169. And again, the question that was being asked to you is about whether or not those were tested and whether or not those hairs were submitted for mitochondrial DNA. You able to review this? Does this refresh your recollection at all?
I remember there was discussion about it. When I send evidence, that report doesn't come back to me. That report goes back to the investigating agency because they're the ones actually taking there, submitting it. I collect evidence and they receive the results, so I don't recall the results of this one.
You don't recall that it came back to being either Latalvis Cobbins or Lamarcus Davidson?
I don't recall.
The state is stipulated that was what the lab deserves.
Okay, thank you. And again, I believe that you saw, when we're dealing with the anal trauma on Mr. Newsom, one of the things that you were able to do is determine when that occurred and that injury happened 1 to 2 hours prior to his death. Is that correct?
That's correct.
No further questions, Your Honor.
Just briefly, and so when you're trying to gauge the approximate time of death from Ms. Christian, you're testifying based upon your observations of the body.
At the time of the autopsy, yes.
So if you had additional information such that Mr. Davidson left the house Sunday night and never returned, he put the body in the trash can Sunday night, do you know approximately how long she would have survived in the trash can?
She could have survived in the trash can depending how tightly the lid was put for, and the question also about the bag, was the bag placed at that time? And the confirmation from the investigation was the bag was placed on the face as put in the trash can. They can actually contract the time, but if the bag is placed on her later, they could actually expand the time that she spent, because she did not die immediately. Could have taken minutes and maybe even hours, depending how she was placed. And you have to remember, once placed, the body just drops gradually because of its own weight. So the way how she was found might not necessarily be how she was exactly put inside that can, because of the movement, because of the sliding. And the other thing is, at which point was the bag placed on the face. So all of those things matter, but her death in the can would not be immediate or very, very quick, depending on all those circumstances.
And if the proof was that if Mr. Davidson had tied the bag around her face and put her in the 5 trash bags and then put her in the can and put the lid on top, and he left the house and everybody was gone, with that, approximately how long would she have survived? If it all happened at the same time.
If all happened at the same time and the bag is applied to the face and she cannot breathe, then that would happen actually in about 5 minutes.
And if that happened, all of that happened Sunday night, then she would have been dead Sunday night.
Sunday night, yes. That's why we always give interval. Interval is anywhere between Sunday afternoon to sometime Monday early afternoon, or Sunday evening to Monday early afternoon.
And the chemical smell, what, if any, effect could bleach have on DNA?
But bleach actually denatures and destroys DNA.
Okay, that's what.
Anything further? No. You can sit down. Thank you, Doctor. Counsel, please approach. We won't be coming to court tomorrow or Sunday, of course. So I'm going to ask you to come back Monday. There'll be a number of things we'll be trying to accomplish Monday, so I won't ask you to get here before 10 o'clock. Please come in a little bit before 10, so we can make sure we get started by 10 o'clock. There's almost certainly going to be media coverage of this trial over the weekend. So again, I caution you, please don't read anything, don't listen to anything, turn away from it as quickly as you can. If somebody calls you on the phone and wants to start talking about the case, hang up. Hang up, don't think anything else. And just put the case out of your mind. It's not time to start trying to figure out what you're going to decide. That only comes after you've heard the arguments of the counsel and you've heard the instructions of the court. So put it out of your mind, have a pleasant evening, and we'll see you a little before 10 o'clock tomorrow. I mean, on Monday.
Or you know what's
You can be seated. We have one other matter we need to resolve before we call upon the state arrest. What's the witness's name we're talking about and discussing?
Adrian Mathis.
All right, in the testimony of Adrian Mathis, as I recall it, the state attempted to elicit responses from her regarding matters that she had testified to in other proceedings. And as best we can recall, they centered around these two issues. Whether or not it was the defendant to whom she loaned her car that first weekend in January, And also, did she find a sandwich bag full of bullets or a bag of bullets in the passenger seat of the car at some point? And her responses repeatedly were, I don't recall, I don't recall, I don't know. So the court did permit counsel to examine her on those issues. And in fact, allowed counsel to just read them word for word and ask her, did you say that? And her invariable response was, I don't know, I cannot recall. So counsel asked for leave to introduce those prior testimonies or statements into evidence as substantive evidence and make them a part of the record. The court did not agree with that at that time. So picking up there, if you all, I'll listen to whatever you all want to put on the record, and I'm going to make a decision one way or the other.
The state, we would rely upon State v. Davis, 466 Southwest 3rd, 49. We believe that we believe Ms. Mathis's previous testimony, we would ask to be able to introduce those two portions that Your Honor referenced under 803.26. We believe that Ms. Mathis's testimony, that she does not recall those two things, we believe that to be a prior inconsistent statement. We believe that her previous testimony qualifies under 803.26 as evidence that we can introduce as substantive proof. We believe that we have satisfied the requirements of 803.26 in that the declarant, Ms. Mathis, has testified at trial. She has been subject to cross-examination concerning that statement, both of those statements. The statements, both of them, were given under oath, specifically at Mr. Boyd's previous trial. And we believe that at this point in time we are conducting a hearing outside the presence of the jury to determine by preponderance of the evidence that the prior statements were made under circumstances indicating trustworthiness. So what this, and again, I am glad that we took time to address this. What the state would ask for is that granted Ms. Mathis has testified multiple times in state court and once in federal court. What the state would ask is for permission to introduce as evidence the federal testimony that she gave at Mr. Boyd's trial, specifically, and drawing your attention back to the weekend of January 6th through January 8th. Were you in your car? Did you have control of your car, or did somebody else borrow it? Her answer being on what date, and then the question being, you're going to have to tell me. I'm trying to draw you back to a general weekend, which is the weekend of roughly January 6th through 8th. January 6th would be a Friday. Her answer being, yes, somebody borrowed it. Question being, okay, who borrowed your car? Her answer being Eric Boyd. Question, your cousin. Her answer being yes. Question being the defendant in the courtroom. Her answer being yes. Further question, do you remember what day he borrowed your car? Answer being either Thursday or Friday. Question, Thursday would be the 5th of January, Friday would be the 6th. Her answer being yes. And then going to she acknowledged that the car was broke down. Then going to page 102, did you find anything else in the car? Her answer being yes, a sandwich bag of bullets. And the question being a clear sandwich bag, her answer being yes. Question of bullets, her answer being yes. And so the state, we're seeking to introduce those two sections. Under 803.26, we would ask that Your Honor find this prior statement to be trustworthy, because this statement that she gave in federal court has shown to be consistent with her testimony that she has given multiple times in state court. But we're only asking to introduce the transcript from federal court, Mr. Boyd's trial. Not the entire transcript, but just the transcript from federal court where she answered those two.
You're saying you're not seeking to introduce the statements made in the state prosecution?
If the state can get in the testimony from federal court, as an exhibit, then that's what that's all the state would be asking for. And I can tell, and Your Honor, my thinking is, I was just going to tell you, Your Honor, my thinking is because in federal court, it was Mr. Boyd's trial.
Right. He had the ability to cross-examine in that one. And that's the only one you're trying to get in?
Yes, sir.
Okay. Okay. That requires that the declarant be unavailable.
Well,
but her demonstration of a lack of memory of the subject matter does support a finding of unavailability. So if you're seeking to introduce it under 804, and that's the only one you're trying to get introduced into evidence, then I think it's not going to be all that difficult to do. You want to be heard, Mr. Curtis?
well, I was just going to say, I'm just saying, I think that, yes, under 804, but we think that it also comes in under 803.26 because she did say she didn't recall.
I agree with that.
Okay.
But you're no longer trying to get, maybe you never were trying to get her testimonies at the other state trials, I think they
Right.
were.
Yeah, I was.
You were?
Yes.
But you're not now.
Right, I'm just trying to get in her testimony at Boyd, and I'm just trying to cover and say, I believe that it comes in under two rules. Under 803.26 because she said she doesn't remember, and then 804.5 because she testified at the defendant's trial.
Well, I agree with you up to a point, but Rule 613.26 is 26. Rule prior consistent statements. Oh, okay, all right, yeah, that's just one thing. All right, Rule 803, Part 26. You're right. She did testify at that trial. It's a written statement. The judge, this is a hearing conducted outside the presence of the jury, and the court does find she's under oath in a court. It was evidently cooperating and giving lucid answers to the questions that were propounded to her. So I would find that the testimony wasn't made under circumstances indicating trustworthiness. However, this is a filtering situation. This rule says you also have to go back and make it admissible under Rule 613B, and that's where you run into it's not admissible until unless the witness is afforded an opportunity to explain or deny the same, and you gave for that the opportunity to an opportunity the problem that we kept bumping into is that she did not deny making the statement, but I don't know that we have to go through this. Okay. It is true the court did permit you to read the state transcripts and ask her to affirm or deny that she made those statements. Those actually were not admissible into evidence, although it's unclear just what it is you get to do when you're examining the witness as to a prior statement. At any rate, it's been suggested that the court should give a limiting instruction to the jury indicating that those statements from the state trials could only be considered for the credibility of the witness and not as substantive evidence.
What about her testimony from federal court?
That wouldn't apply in federal court. In federal court, you can get it in as substantive evidence.
Thank you.
Can I respond before we rule? The only thing that I would say, and this is where I have a little bit of concern, and I'll just direct you, Your Honor. It's going to be in subsection C under 803.26. And that's where the prior statement was made under circumstances indicating trustworthiness. And we did have a jury out hearing in this court. And my recollection of Ms. Mathis's testimony is that she was basically just repeating the statement that was being shown to her and repeating that in federal court when she testified. I do have some concern about whether or not that indicates sufficient trustworthiness for her prior testimony. So that's where I have pause for concern. I believe in the jury out hearing that we had in this trial, she at least would indicate, based on her testimony here in this court, that she wasn't necessarily testifying truthfully. So that's where I have a pause for concern.
I think the court's interpretation is going to be that she did indicate, I believe in response to questions, that if she answered a question back then, it would have been a truthful answer.
Yes.
And all she's saying now is she just can't remember now what happened, where those answers came from now. But that at the time, if she could answer a question, it would have been a truthful answer. So based on those findings, or find she is unavailable because she has demonstrated a lack of memory of the subject matter. And on that basis, she's unavailable, and her prior testimony was subject to cross-examination by the defendant in federal court, and the requirements have been met, and the court will permit the state to put the statement in as substantive evidence.
And so, Your Honor, what the state would like to do is we can take leave and redact. What the state wants to do is we want to redact out everything else from her transcript, unless the defense wants it, and just submit those two areas that the state just read into the record.
If I can review what they've got. I mean, given the court's ruling, we may be able to agree based on the court's ruling as to what they can submit. Sure.
All right, thank you.
And then we will make that an exhibit to this trial on Monday.
So you want to go ahead and rest and make that a legally filed exhibit?
We were going to read it Monday in front of the jury, and then make it.
Okay, it's all right with me. We'll wait until Monday for the rest. Okay. All right, then. At this point, the court will adjourn the court, but we'll ask counsel to remain either in my chambers or in court to try to reach a final agreement as to the instructions that you want the court to get.
Thank you.
All right, we will let's just meet back here at 9 o'clock Monday, and we'll